Matter of Loehr v. Administrative Board of the Courts of New York State. Thank you.
May it please the Court, Lee Adlerstein, on behalf of the Office of Counsel, Court Administration, on behalf of the Administrative Board. And if I may have 2 minutes rebuttal?
Yes, Counsel.
Okay. The Administrative Board, in this instance, acted in a manner in which it believed to be in the best interests of the court system as a whole. Exercising a unique and what this court in the Marrow case has termed nearly unfettered discretion.
But isn't that case about individual determinations? And here what you have is a policy that you're applying across the board, regardless of any individual circumstances of any individual applicant for certification.
The specific issue in Marrow dealt with supposed individual criteria, but the court spoke much more broadly than that in setting out in the Marrow case what the certification process is all about. The court in Marrow made it very clear that what is happening when somebody applies after reaching the age of 70 in mandatory retirement as a judge for further certification constitutes the application of a retired person. Some judges retire.
Well, what's the criteria? What's the criteria that guides the board? Constitutionally, statutorily, what is it?
Yes, the criteria are twofold. One is that the person be mentally and physically fit for the job.
Which is not an issue here.
No,
not
it is not an issue here. It could be an issue in individual cases. And the second one is that the board makes a decision and makes a determination based on what is necessary to expedite the business of the courts.
Though that's where I have, I think, the greatest challenge in understanding the argument. Isn't that criteria about human resources?
Not just human resources, Your Honor. We don't think it's that limited. The Marrow case made it clear that the board has, as I stated, nearly unfettered discretion.
Is there any definition, counsel, of necessity or what is necessary in that guideline?
No, there is no.
So it's basically up to the administrative board to determine what necessary means.
Yes, Your Honor. The legislative history doesn't seem to point to anything. If one looks at legislative history, if one uses the word necessary, it's still up to the board about what is necessary.
Could the board waive this policy in individual cases? For example, have an overriding policy that it is not necessary for judges who are collecting their judicial pension to be certificated. Could the board find in one or more individual instances that it was necessary? So allow certain judges who are collecting their pensions to be certificated?
The answer to that is perhaps. This decision on the part of the board was enunciated in an administrative order. And I don't believe that the board would not follow its administrative order in all instances. What Your Honor is probably talking about is the administrative board needing to issue another administrative order, specifically tailored to a specific situation.
I'm talking about more like a waiver of,
Right.
There are various situations in which all kinds of policies and procedures are waived. Could it be waived in individual cases?
The answer to that is perhaps. It's certainly not the situation that we have in front of us today.
Can we take a step back for a second? What's commonly referred to as double dipping is, in point of fact, legal in New York, isn't it? There are a number of judges, to my own knowledge, who retire early, or usually they retire about 3 days before they're sworn in again, and they collect their judicial pensions, and then they also continue to collect their salary as judge after they've collected a pension, or I say judicial, but it could be from being a police officer or anything else, but nonetheless, it's relatively common.
It does happen in some instances. It's not prevalent.
My understanding, so it has happened and it is legal. So I guess the question is then, is the action, it's not the legality of the action, but whether or not the criterion is a rational exercise of your power. And that pushes me towards an argument that I think may or may not have been properly preserved by the petitioners, but I'd just like to ask you to respond to it. And that's the argument that really the Court of Appeals has to rule on this case and not just the board. That seems to be, well, it was poorly preserved, but it may be a powerful argument. What do you have to say to that?
Well, it wasn't preserved, and...
Okay, but let's assume it was.
And there's nothing in the record as to what kinds of consultations may have taken place. So that is a factor. And at the same time, if one looks at the provision itself in the Constitution and the provision in the Judiciary Law 115, the Administrative Board is given this unique power.
Well, listen,
the narrow case talks about it.
Yeah, but take a step back. You yourself said this is a statewide policy. The statute refers to the Court of Appeals approving any statewide policy. How does it not apply?
This is a unique power on the part of the Administrative Board.
So you're saying that the statute 211 is in essence ignored or overruled? Tell me what the basis of your argument is.
It's not applicable here because we're talking about an appointive process. The court in Marrow said that when the Administrative Board makes a decision on who to certificate as a judge, it's basically making an appointment, which is essentially the equivalent of an executive appointment of a person to what the court characterized as one of the highest offices
Yes, but
in
to
the
that
state.
point, Marrow's
Yes.
analysis is based on what the court there articulated as the weighing of what must be personal, if not private considerations. It's about what are these unique assessments of the personnel of the individual applicant. In this case, you just have a blanket rule that is ignoring the qualifications of the individual. It looks to me like it's an additional criteria that's not set out in the Constitution, not set out in the statute.
Well, what the Administrative Board was doing here is it was enunciating openly a criteria which it felt it needed to have in place because of the best interests of the court system.
But let's say we agree with that. It seems like a rational policy. Slow down a second. It seems like a rational policy, but the only question really is was it properly put into place? I think that's the question for us.
But aren't you saying that if it had been properly preserved, you would have at least had the opportunity to make this argument before the lower courts?
That's correct, and there's nothing in the record to indicate what kind of consultation had taken place between the members of the Administrative Board and the members of the court in that connection. And also, one should bear in mind, I think, that the policy has not yet been promulgated. We're in front of this court.
No, it isn't the issue what the word necessity means and whether or not, as the board has defined it, we are in agreement with that interpretation of the statute and the Constitution? Isn't that what this boils down to? There are only two criteria. One is not at all relevant. There's only this other criteria.
I think what we're talking about, Your Honor, is the question of whether this was a rational decision. And I think that it's already been established that...
All right, I'll go with that.
That's consistent.
But
Yes.
doesn't that turn on whether or not it's rational based on what we say is the definition of necessity? Can't be
Yes.
rational if it doesn't meet the definition.
Yes, what is necessary is something for the Administrative Board to weigh. It is not a word of limitation. The court in Marrow said that there's no right to appointment, that the Administrative Board has discretion here.
Okay, so then what's the line in the sand? I understand your point about Marrow said the board has this unfettered discretion. Is there no line in the sand? Is there no point at which there is a judicial interpretation of what is necessary? So it's whatever the board says is necessary?
Well, what the court in Marrow said is that the board's decision is not subject to judicial review except for claims of substance that there had been a violation of a statutory prescription or promotion of a constitutionally impermissible purpose unrelated to the certification
But
process.
then what would be the point of this particular criteria in the Constitution and the statute? If truly there's the kind of unfettered discretion that you're talking about, which is the board can decide whether or not to certificate someone on whatever grounds. It's basically what you're saying. So what would be the point then of this criteria as it is expressed? Necessary to expedite the business of the court. It doesn't say necessary to the integrity of the court, necessary to the business, even that, to expedite the matters of the court.
Well,
Doesn't the language itself suggest you're talking about human resources? Do we need this person to do some particular job?
But isn't always necessary in a hiring sense have an economic component to it? I mean, anything could be necessary to expedite, and the more bodies you throw at anything, the more it's going to be expedited. So isn't there implicit in this necessary clause? I know it's New York, but even here, that we have an economic concern as to what's the balance between more bodies and efficient functioning of the court.
Well, if Marrow stands for anything, it stands for the fact that the board has to look at situations as they come. In this situation, the board was looking at the fact that there was certain pressure on the court system that was real and that was tangible. It came against the background in which the courts had recently had to engage in a lot of layoffs. It came under a budget pressure. It came under a situation in which the practice of what's called double dipping had been increasing. It came as happily judges were starting...
Isn't that then a question for the legislature?
It may
Not
be,
the board?
It may be a question of the legislature, but the board is given
But as Judge
discretion.
Faye has said, it's legal.
The board is given discretion to weigh that, and there are prescriptions on double dipping under New York law.
But not in this case, right?
Not in
It's
this-
totally legal here.
It is permissible if the board had wished to continue a situation where double dipping was permissible and it would certificate judges in the face of it, yes, that would be legal. However, it's also
The
legal.
question is whether it's required.
That's right.
Isn't your strong, maybe I'm missing something, but it seems to me your strongest argument, which I'd ask the other side to address, is this isn't a question of double dipping, it's a question of the right to certification. Isn't that really what we're boiled down to
I think that's very much true, and I think that here we're talking about some very tough decisions that the administrative board has to make.
Was it
And
the right
fact
to
that it hasn't-
certification or to an employer to require an employee to give up what they're legally entitled to get if they want?
Well, they're not asking the court, anybody to give up anything. That what's happening here is that judges are given a choice between accepting the position as a certificated judge or deferring their pensions.
What if the board said, you know, you complained about a rule we passed a year ago, we're not going to certificate you? What if that was their rule? If you complain about anything we do, you can't get certificated. Could they pass that kind of a rule, and could they impose that kind of a rule?
Well, then we get into a question
I mean,
of...
isn't that about necessity? We don't want people who are objecting to our rules. It undermines our authority.
That would get into possible First Amendment
Yeah, but this is a
tests.
constitution. They're arguing that they have a constitutional right and a statutory right to this.
But they
too.
don't have a constitutional right to be certificated. That's the point.
No, but they have a right to get their pension while they're working in this position.
But they
And that's
also-
what they're being asked to forfeit, right? To give up.
They're being asked to make a choice. That's the way it lies. The board had to weigh what was in the best interests of the court system as a whole.
Thank you, Counsel.
Good afternoon, Your Honors. May it please the Court, my name is Robert Spalzino, and I represent the respondents, Justices Gerald Loehr, J. Emmett Murphy, and William Miller.
There's no entitlement to certification, right?
No,
To being
Your Honor.
certified, no.
There's no entitlement to certification, but there is entitlement to be considered for certification, like every other justice and in accordance with the statutes and the Constitution. That's what this case is about, and it's particularly about that.
Well, they were
because
considered and found lacking, right?
They were.
Isn't that the point?
Well, they were considered and found, let me say this right, certificatable, but for the fact that they were receiving retirement benefits from prior judicial employment.
Why is there an entitlement to be considered for certification? Where does that come from?
there's an entitlement, they have the same right as any other Supreme Court justice to put their names in it to be considered. What's happened here is that the administrative board has deprived them of the choice that they have to collect their pensions, which the choice which is protected not only by retirement Social Security law, section 212, right? This is double dipping is a mischaracterization, as Judge Fahey pointed out.
Can I ask you about 212, though? Because 212 seems to say it protects their right that's provided under 212, right? That it says this section.
Mm-hmm.
But it doesn't, it says notwithstanding, section 211 says notwithstanding the provisions of 212, and then there are things that deprive people of the right to have a pension under 211. Have you considered the interplay of 211 and 212?
Yes, but 212 specifically says once you hit age 65, you can earn whatever you
It says
you
that
want.
it says the limits, I think you can look at it, but I think it says the limits in this section 212 don't apply. 212 says once you hit 65,
Right.
the limits in 212 don't apply.
Correct.
But it doesn't, how does that interplay with 211, which
There's,
has different limitations?
but not that would apply here,
Because,
because these justices have retired and are receiving their retirement benefits. I'm not following what you're asking, Your Honor.
so your position is 211 is inapplicable to?
211, right, this is governed by 212.
Only.
212 plus the Constitution, the constitutional right to collect their benefits and to not have their
I
retirement.
have a hard time understanding the constitutional argument because they can collect their pension. The question is, can they do that while they're serving in this capacity? So if they want to collect their pension, no one's taking your pension away. So to me, it seems like it comes down to whether 212 gives you the right to do that or it gives you the option to do that. That to me seems like the real issue in this
That's where the
case.
deprivation comes in exactly, Judge Garcia.
So
which is the-
what does may mean? And I think you're hearing some skepticism on the Marrow case, and does it give this? And I think a lot of us are concerned that it does not say that. But it does say, I think as Judge Wilson said originally, it isn't an entitlement, it is an enablement. So that, I think, is somewhat relevant. And the language may. So given Marrow's enablement language and the language of may in section 212, what would prevent the state from saying this cost to us of certifying or certificating a judge in this position is too high? So we're going to say it's not necessary in that case to spend X plus Y to have this judge in this position.
Let me, I want to address what I think is I don't want to say misunderstanding or clarity in what you're saying they're doing, but I also want to address the constitutional argument.
But just
as well.
assume for a second we're not addressing the I'm not as interested in that in this question.
Okay.
So let's go to the statute.
So let me try. Let me try to do it this way. They're not getting anything. They're not getting anything extra by what they're doing. They earned their retirement benefits. Those benefits stopped on the day they elected to become retired, and now they're getting paid for work they're doing going forward. So the state is not paying them anything extra. That's the factual concern I had about what you said. The Constitution, and I hate to get back to the Constitution, I know you don't want to hear it.
The cost to the state is greater. The cost to the state is greater in certifying a judge who's collecting a pension than certifying a judge who isn't, right?
Well, I would disagree with that respectfully, Your Honor, because...
Who's paying the pension?
Well, the state pension fund is paying the pension. Those funds have been paid in already by the judge and by the state, and that money's coming out of a pension fund. Actually, the cost of having an additional judge is less than than electing another judge, because they're not paying, the state's not paying, or the administrative board, the Office of Court Administration, is not paying retirement benefits for the certificated judge.
Well, what about the circumstance where you have, let's say there's a need for one judge, and there's two possible candidates, and one has a lower pension than the other? Is it illegitimate for the administrative board to pick the one who has the lower pension cost?
Yes, and the reason I would say that, Judge Wilson, is because the cost to the state going forward is the same. The judge's salary going forward. The judge is entitled to receive his pension based on everything that's happened before, all of his employment before.
So do you view the two criteria in the Constitution, that is health essentially and ability, necessity, as limiting factors or necessary conditions but not sufficient?
I submit that they're like any other factor in an enabling statute, which says to an administrative body, you can do this in accordance with these criteria.
You can do these, if these criteria are met, can you consider other criteria or no? No.
You're bound. I submit that the administrative board has no authority to make up additional criteria.
Counsel, even if you're correct about whether the cost to the state is the same or less, is the state able to address the perception that the cost is more?
I think there's a fundamental misconception about what happened here, Judge Abdus-Salam, about what was in fact considered. I mean, there's no dispute that this policy was adopted in one day on the basis of a comment by the governor that appeared in the New York Post, or the Daily News. So it's not like this was some considered policy over many months where people were consulted. I mean, the record even reflects that the official who is involved with judicial benefits for the state of New York didn't even know about it until we brought this lawsuit. So this was not some considered policy having to do with that. It had much more to do with Proposition 6 than it had to do with anything else.
But also, if we take the chief administrative judge at her word, it was concern for the budget of the court system, which is dependent upon the other branches of government and the impact that that would have on the court system. And why is that not a legitimate economic concern? And it goes to Judge Abdus-Salam's question about perception.
Well, I have great respect for the chief administrative judge, but it's hard to believe that that's a significant, that this pension issue will be a significant factor with the other branches of government when the chairman of the Assembly Ways and Means Committee is doing the same thing as is the former chairman of the Senate Judiciary Committee. There are 2,600 state employees who are receiving pensions, post-retirement benefits,
But is it within the board's discretion to perhaps calculate this and come out differently from where you come out? Isn't that within their determination?
That's the second point I was going to make, Judge Rivera, which is this, that, as I expressed earlier, I would submit that the administrative board can't make up its own criteria. It's bound by what's in the Constitution and the statute, and what the Constitution and the statute say is necessary to expedite the business of the court. Now, how a judge, such as these three...
Let me ask you this, Mr. Spolzino. Could we do it? Could the Court of Appeals make such a policy?
No. I don't.
So in other words, let me just finish that.
Yep.
So your argument is that this policy had to be approved by the Court of Appeals, but no, we couldn't approve it. We could not make this policy.
I believe that's correct, but it still would have to be approved.
So let me just finish it for my own purposes. Assuming that the issue was properly preserved, which appears to be doubtful, the Court of Appeals rules on the policy. Could the Court of Appeals rule on the policy either up or down in the context of this lawsuit, or would a separate action have to be brought? In other words, could we say yes to no certification for judges, retired judges, or yes to it in the context of this lawsuit, or given we exercise independent power from the board? If we say the board does not have the power, the Court of Appeals does have the power, could we answer the question as to whether or not the board policy is proper or not in the context of this lawsuit?
In the context of this lawsuit, there are 2 points with regard to that. One is, and I would respectfully suggest that it was sufficiently preserved. It wasn't in the pleading, I'll admit, but it was sufficiently preserved by raising it at the appellate division in a situation where there's no undisputed fact here. If you decide that it was preserved and you decide that it is a statewide policy, which I would submit that it is, then you could strike this rule down on that basis alone.
In the context of this lawsuit, or we could approve it?
Or I don't believe that you could approve it. I believe you could also find that it is not a proper policy, and that it's an unconstitutional and illegal policy, which it is. To get back to where I was, the administrative board, there's no use of the English language in which the word necessary to expedite the business of the court involves whether the judge who's in question is getting retirement benefits or not. The administrative board decided these judges were necessary, capable and necessary if they gave up their retirement benefits. That doesn't affect, as Judge Garcia said, the economic component. This doesn't affect anything. The receipt of retirement benefits doesn't change by any use of the normal use of the English language, whether these judges are necessary.
My point on that was, you can always say more bodies are necessary to expedite. It's just math. So if I had 15 cases and I had 15 judges, it would be expedited. But that doesn't mean it's necessary.
No, but the administrative board could quite clearly have said, and we wouldn't have been able to challenge it, we only need one judge, one certificated judge this year, and it's going to be X.
Right, but the point is you can factor economic concerns into the necessary analysis. And if there are economic concerns, whether it's the more general, our budget may be affected, or where is this money coming from, why can't you, if you're admitting you can factor economic concerns in, 15 judges make that 15 caseload go a lot faster, why can't you do it to factor in other economic concerns?
Because the economic concerns involving retirement benefits have no bearing on the budget or the expenditures of the Office of Court Administration.
Could the board make the determination one judge at a time, not promulgate a policy, but just every single judge that appeared and sought recertification, and they said, no, we don't think you're necessary, without giving a reason? Because, I think Morrow says you don't have to give any reason. So what if they never said anything at all? They just systematically denied the application of every judge that was collecting a pension. Could they do that?
Then they might have been able to rely on Morrow. But that's not what happened here. What happened here is they promulgated a policy, and that policy is illegal and unconstitutional and violates both the statute and the respondents' rights. Thank you, Your Honors.
Just a couple of points, starting with the discussion about Section 212. Section 212 does not create a situation where an employee of the state of New York, including a justice of the Supreme Court, can retire and then start collecting their pension and then automatically expect that they are going to be rehired. It doesn't guarantee rehiring.
No, I think the question is whether or not they should be put in a worse position because they are collecting a pension that they're legally entitled to.
Well, that is a determination for the particular judge to decide, given the option of continuing in service as certificated or not, which is within the particular discretion of the court. And then on the...
Are there any, I'm trying to find a good way of articulating this question for you, are there any categories of conduct or status that the board could not take into consideration with respect to a justice who applies in trying to figure out this criteria, the necessary criteria?
Well, again, what the court said in Morrow is that something that's constitutionally forbidden or something that's contrary to law. And so one could think of various kinds of perhaps invidious determinations that could be made that could be factored here. Of course, this case is far different from that. And if I may...
You say this is not contrary to law, even though they're entitled, and legally they can get this pension. Say that's not contrary to that statute.
Correct. They can get the pension. What's happening here is...
Is that because because the board is just saying you have to delay collection? Is that why it's not contrary to the statute?
It's not contrary to the statute, yes, because the board is not taking away anything. This court in Morrow said that there's no property right here to be reappointed to the courts. It's really a matter for the board to determine. And then when counsel suggested that the board would have the authority to have, in a way, sub rosa determined on a case-by-case basis that it would not certificate people who were applying for judgeships because they knew that the person was going to be looking to retain their pension. What the board did here is it openly wanted judges to know going in what their choice was. And I think in that matter, the board acted absolutely appropriately, considering the various responsibilities that it had.
So just to clarify for me, let's say that the court agrees with you, right? And a justice is certificated who indeed agrees to these terms. Does that mean that can the justice at any time in the 2 years, let's say it's a 2-year certification, change their mind?
Yes, a judge can retire, and then...
That's what I'm saying. So obviously, they could change their mind and choose to want to get this pension by retiring, which means then they give up whatever time they have left on the certification.
That's correct.
Yes?
The judge would have the ability to retire. The judge had to have retired once.
Yes.
And now the judge would be retiring for the second time. And
Counsel,
then-
I'm sorry, 212 itself is elective, right? A judge would have to, it's not a default that you can do this. If you retire and collect, you have to elect under 212 to be able to double collect,
Yes,
right?
yes, I think
And
you
you
do.
also can elect not to do it, as I read this
That's
statute.
correct, and many people do. It's not the prevalent practice, certainly. And then I'll just leave with the
If it's
thought...
not a prevalent practice, then what's the concern? I mean, how many people is the board really concerned about that creates such a terrible public impression?
concern is that it's increasing. The concern is that it's increasing. The concern is that...
From what
as-
to what? What are these numbers going to look like?
Well, I think there's something like 80 certificated judges now, and a certain number of them are double dipping, but not a majority of them. I think the concern is also that as judicial salaries are happily increasing, we already have a chart in the record that shows that some judges who are double dipping are getting more than $250,000 a year in a combination of their salary plus their pension. And that's-
If the court
those
agrees
numbers-
with you, is the board going to ask the people who are collecting their pension, what is the board going to do? Let them finish off their certification period?
I think that there's a stipulation in effect. The board had made it clear that the rule was prospective.
I see, okay.
And there's a certification in effect that everybody has everything in place and then can make their election after this court rules.
Thank you. Thank you,
Thank you.
counsel.